If you're writing offers on multi-unit properties in California, this one contract can save or destroy your deal. The Residential Income Purchase Agreement, or RIPA. In this video, I'm going to break down the RIPA step by step in plain English so you can write cleaner offers, avoid the most common mistakes, and protect your buyer or seller, especially with the 2024-2026 form changes and best practices. We'll cover what to watch for what to negotiate, and the clauses that agents miss that can lead to canceled escrows, disputes, or lost commissions. If you want to stand out as the agent who actually understands California income property contracts, you're in the right place. Let's jump in. As a quick reminder, this video has a written presentation to follow along. Don't forget to download a copy from my training website so you can print it, follow along, study it, and make notes. The link to the training website to download this presentation is on the screen and in the video description. And if you enjoyed this training, be sure to subscribe, like, and comment. Our training package today is structured to give you a clear and thorough understanding of the critical documents in an income property transaction. We'll begin by diving into agency disclosure, a foundational element in all real estate dealings. From there, we'll spend significant time dissecting the Residential Income Purchase Agreement itself, going through its key sections. Finally, we'll cover essential advisories and addenda that often accompany these transactions, providing crucial context and protection. A fundamental aspect of our profession is understanding and properly disclosing agency relationships. This involves clarifying whether you represent the seller, the buyer, or if a dual agency situation exists. Each role carries distinct duties and responsibilities. As a seller's agent, your primary duty is to the seller. As a buyer's agent, it's to the buyer. A dual agent represents both parties, requiring meticulous attention to neutrality and confidentiality. Clearly defining these roles from the outset is paramount for transparency, and to uphold our ethical obligations to all involved in a transaction. Beyond specific loyalties to either buyer or seller, all agents owe universal duties to both parties in a transaction. These include exercising reasonable skill and care in performing your duties. Essentially, doing your job diligently and competently. You also owe a duty of honest and fair dealing, fostering good faith in all interactions. Crucially, you must disclose all known facts that materially affect the value or desirability of a property, unless those facts are confidential information from your client. It's important to remember that real estate broker commissions are always negotiable and not set by law. When acting as a dual agent, there are specific restrictions and heightened responsibilities to be aware of. A dual agent absolutely cannot disclose confidential information about one client to the other without explicit written permission. This includes financial positions, bargaining strategies, or a willingness to adjust pricing. All agency relationships must always be confirmed in writing. It's also vital to remind our clients that while agents offer professional guidance, buyers and sellers ultimately bear the responsibility for protecting their own interests. Always encourage them to review agreements carefully and seek independent professional advice where needed. Let's now focus on the core document, the Residential Income Purchase Agreement, or RIPA. This is the blueprint for the entire transaction. It's crucial to understand that while brokerages facilitate these transactions, the brokers and agents themselves are not direct parties to the purchase agreement. Their role is to represent and advise their respective clients, the buyer and the seller. Thoroughly understanding each section of this agreement is essential for properly guiding your clients and ensuring a smooth and legally compliant transaction from offer to close. Navigating the RIPA means understanding its critical terms and timelines. For example, the purchase price, whether all cash or financed, is central. The close of escrow is typically 30 days after acceptance, but can be specified differently. Offers usually expire within 3 calendar days. Initial deposits are generally due within 3 business days after acceptance. Loan, appraisal, and investigation contingencies commonly default to 17 days, allowing buyers time for due diligence. Finally, a final verification of property condition is typically performed 5 days before the close of escrow. Knowing these benchmarks is key to managing expectations. Contingencies are vital protective clauses within the RIPA, shielding your clients during the transaction. We primarily deal with loan, appraisal, investigation, and often insurance contingencies. The loan contingency protects the buyer if financing falls through. Appraisal ensures the property value supports the loan. The investigation contingency allows for thorough due diligence, and an insurance contingency ensures insurability. It is critical to advise clients against removing any contingency without having all necessary information and being fully satisfied with their findings. Once removed in writing, those valuable rights are relinquished, exposing your client to potential risks. Understanding what is included in the sale and the mandatory seller disclosures is paramount. The RIPA clearly specifies that all existing fixtures, fittings, and built-in appliances, along with specific items like solar systems or pool equipment, are typically part of the sale. On the disclosure front, sellers are required to provide a transfer disclosure statement, natural hazard disclosure, and various other statutory disclosures. For properties built before 1978, lead-based paint disclosures are mandatory. Additionally, disclosures related to home fire hardening, natural hazards, HOA information, and any permits are critical for the buyer's informed decision-making. For residential income properties, tenancy disclosures are crucial. Sellers must provide current leases, rental agreements, income statements, and, if checked, tenant estoppel certificates, with security deposits transferring to the buyer at close. Any significant changes during escrow, like new leases, require at least 7 days' notice to the buyer, who then has 5 days to object. At the close of escrow, various items like property taxes, HOA assessments, and rental payments are typically prorated on a 30-day month basis. Both buyer and seller provide joint escrow instructions, and a copy of the agreement is due to escrow within 3 days after acceptance. It's vital to understand the dispute resolution mechanisms within the RIPA. The liquidated damages clause, if initialed by both parties, limits the seller's recourse to the buyer's deposit, capped at 3% for owner-occupied 1-4 units, if the buyer defaults. Mediation is typically a mandatory first step for disputes before arbitration or litigation. Parties agree to attempt resolution through a neutral third party, often through CAR's Dispute Resolution Center. If the arbitration clause is initialed, unresolved disputes then proceed to neutral binding arbitration, often with a retired judge or an attorney specializing in real estate law, providing a definitive resolution outside of court. The process of offers and acceptance forms the contractual foundation of every transaction. A buyer submits a formal offer outlining all terms and conditions. The seller then has the option to accept the offer, reject it, or issue a counteroffer. This negotiation process continues until both parties have reached a meeting of the minds and formally signed off on the same terms. As real estate professionals, it's our role to accurately present these offers, clarify their implications, and guide our clients through each stage of negotiation towards a binding agreement, ensuring all required brokerage details are properly recorded. Federal reporting requirements, specifically FinCEN rules, are designed to combat money laundering in real estate transactions. While certain requirements scheduled for 2026 were temporarily suspended, it's crucial to understand when such reporting might apply. It typically involves properties with 1-4 residential units, where the buyer is a legal entity or trust, and the purchase is all cash or financed through a non-reporting institution. Required information can include legal names, dates of birth, tax IDs, and citizenship of all parties, including beneficial owners. Timely delivery of this information, usually within 7 days of request, is essential for escrow to close. The Buyer's Investigation Advisory emphasizes the buyer's critical responsibility to conduct thorough due diligence. It clarifies that a broker's visual inspection is limited, and buyers must actively investigate all aspects of the property. This includes checking the general condition of foundations, roofs, and systems, as well as environmental factors like soil stability and drainage. Buyers should also explore insurance availability and potential hazards, like fire or flood zones. For income properties, understanding rental restrictions and local rent control laws is equally vital. Empowering buyers to investigate ensures they make informed decisions and protect their interests. The PRBS advisory addresses the reality that a single brokerage may represent multiple clients who could have competing interests. For instance, different agents within the same brokerage might represent multiple buyers interested in the same property, or the brokerage might have several listings that appeal to the same pool of buyers. This form also reiterates consent for dual agency, confirming that the brokerage can represent both buyer and seller. In such cases, confidential financial or bargaining information remains protected unless express permission to disclose is granted. It's important to clarify that offers are not confidential unless a specific written agreement is in place. Fair housing is a cornerstone of ethical real estate practice. This advisory reminds us that all housing in California must be available to all persons, without discrimination. Federal and state laws strictly prohibit discrimination in housing transactions based on protected characteristics, such as race, religion, gender, sexual orientation, disability, and source of income, among many others. Familiarity with the Federal Fair Housing Act, California's Fair Employment and Housing Act, and the Unruh Civil Rights Act is essential. Upholding these principles is not just a legal obligation. It's a moral imperative that promotes equitable access to housing for everyone. To further understand fair housing, it's important to recognize examples of prohibited conduct. This includes refusing to negotiate or sell based on a protected status, steering clients away from certain neighborhoods, engaging in blockbusting, or publishing discriminatory advertisements. Refusing reasonable accommodations for individuals with disabilities, or retaliating against someone for asserting their fair housing rights are also clear violations. Should you or your clients encounter such issues, numerous resources are available, including federal HUD, state agencies, local fair housing councils, and CAR. Violations can lead to significant civil fines, damages, and legal action. Two critical advisories every realtor should discuss with clients are homeowners insurance and wire fraud. For insurance, recent challenges in California, like rising costs and limited coverage due to natural disasters, mean buyers must explore options early and consult with a qualified insurance professional. Never assume coverage will be readily available. Secondly, wire fraud is a persistent and dangerous threat. Hackers frequently intercept wire instructions. Always advise clients to verify wire details by calling known contacts using phone numbers obtained at the start of the transaction, not from suspicious emails. Considering alternatives to wire transfers, like cashier's checks, is also a prudent safeguard. The California Consumer Privacy Act, or CCPA, grants California residents significant rights over their personal information collected by businesses. In real estate, personal data is routinely shared among various parties. The CCPA gives individuals the right to know what information is collected, sold, or shared, and with whom. It also includes the right to correct, delete, inaccurate or unwanted personal data, and the right to opt out of the sale or sharing of their information. However, be aware that despite opt-out requests, real estate brokers and MLSs are often legally required to retain certain records for several years, balancing privacy rights with legal compliance. Before we end, and as a final reminder, this video has a written presentation to follow along. Don't forget to download a copy from my training website so you can print it, follow along, study it, and make notes. The link to the training website is on the screen and in the video description. And if you enjoyed this training, be sure to subscribe, like, and share, and always remember to refer clients to an attorney, CPA, or other qualified professional for any specific legal or tax advice. As we conclude, let's recap some key takeaways to impart to your clients, whether they are buyers or sellers of income properties. First, ensure they fully understand their agency relationship and their agent's duties. Second, emphasize the importance of reading and understanding every single page of the residential income purchase agreement. It's their contract. Third, stress the necessity of thorough investigations and due diligence as the buyer's responsibility. Finally, always educate them on protecting themselves from potential fraud, especially wire fraud. By reinforcing these principles, you empower your clients to navigate their real estate journey with confidence and security.